This is the seventh video on revision series on Indian polity. The whole purpose of these videos is to make your revision faster, easier and convenient, and to make this series one-stop solution for your Indian polity. We are trying to finish Indian polity well before this year's prelims examination. You can find the playlist link down below in the comment section or in description box. You can download these notes in digital format from paid PDF membership, or you can just grab pen and paper and make running notes along with me. So without wasting time, let us begin with the seventh chapter, that is Fundamental Rights. Part 3 of the Indian Constitution from Article 12 to 35 deals with fundamental rights. These fundamental rights are inspired from Bill of Rights of America. It is said that fundamental rights establish political democracy. But how? See, fundamental rights prevent despotic rule and they promote rule of law. They create government of laws and not of men. That is how fundamental rights establish political democracy. If your fundamental right is violated by anyone, be it individual or state, you can directly go to Supreme Court of India. So that is what makes a fundamental right special. Originally, there were 7 fundamental rights: right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, right to property, and right to constitutional remedies. But right to property under Article 31 was abolished. It was deleted by 44th Constitutional Amendment Act of 1978 and made it a legal right under Article 300A. So right now we have 6 fundamental rights. In the chapter of citizenship, we learned that some fundamental rights are available only to citizens. These are Article 15, prohibition of discrimination on certain grounds; Article 16, equality of opportunity in public employment; Article 19, 6 rights and their protection; and Article 29 and 30, these are cultural and educational rights. Now these rights are available only to citizens. Now let us discuss some features of fundamental rights. As I said just now, some fundamental rights are available to citizens and others to all. Fundamental rights are not absolute. There can be a reasonable restriction on them on grounds of decency, morality, sovereignty, integrity of India, etc. So these fundamental rights are not absolute and there can be a reasonable restriction. Some fundamental rights are available against state and some against private individuals too. Some fundamental rights are negative in character as they put limitation on state or prohibit the state from doing something. Fundamental rights are suspended during national emergency except Article 20 and Article 21. Now what are the Article 20 and 21? Just wait, we will learn them in this video only. Now Article 19 can be suspended only when emergency is declared on the grounds of war or external aggression. Article 19 contains 6 freedoms. So Article 19 can be suspended only when emergency is declared on grounds of war or external aggression. Do not worry, as of now, we will finish emergency chapter, then you will understand this in detail. Also, we have not covered Article 20, 21 and 19 in detail, so do not worry, we are doing this in this video only. Scope of fundamental rights is limited because preference given to some provisions in the Constitution. For example, if acquiring estate of someone is important, then fundamental right of that entity can be violated. If some provision is kept in the 9th schedule, then it can be challenged in court of law even if it violates fundamental right. Schedule 9 is iron box. Whatever parliament puts in it will not be questioned in court of law. ऐसा पार्लियामेंट का मानना था, बट आगे जाके सुप्रीम कोर्ट ने बोला कि नो प्रोविजन कैन ऑल्टर बेसिक स्ट्रक्चर इवन इफ अ लॉ इज पुट इन शेड्यूल 9. Also, some directive principles are given preferences over fundamental rights. So this limitation of fundamental rights is mentioned under Article 31A, 31B and 31C, जिसके बारे में हम लोग डिटेल में पढ़ेंगे at the end of this video. Fundamental rights of armed forces personnel can be restricted under Article 33. In case of martial law, application of fundamental rights can be restricted under Article 34. Do not worry, we will discuss this in detail under Article 34. Some fundamental rights are directly enforceable, while some need a law which can be made by Parliament. For example, a Parliament can make a law to enforce untouchability. Since Article 17, that is abolition of untouchability, is not enforceable in itself. So these were the features of fundamental rights. Do not worry, we have not started yet the chapter of fundamental rights. We have not dealt with articles. We will discuss all these in detail while explaining articles one by one. So now let us start with articles related to fundamental rights one at a time. Article 12. Article 12 defines state for the purpose of Part 3. Part 3 is part of Constitution where fundamental rights are mentioned. Article 12 says that state includes number 1, the government and Parliament of India. When we say government in Article 12, it means and it largely implies executive here. Second, the government and the legislature of each state of India, that is executive and legislature of each state of India. Third, all local authorities such as panchayats and municipalities. These are legally entitled to perform government functions. So these are local authorities. Number 4, other authorities. Other authorities means statutory or non-statutory bodies like LIC, ONGC, SAIL, GHAIL, BHAIL, etc. Now what is the test for determining if other authorities is part of state or not? In Ajay Hasia case, Supreme Court gives criteria for that. If entire share of capital of the body is held by the government, or if there is existence of a deep pervasive control, state control, then it comes under state. Or if functions performed are of public importance and closely related to government functions, or if it is performing public duty, then that body can be part of state. That authority can be part of state. Let us understand with example. Is BCCI a state? This question popped up in BCCI versus Cricket Association of Bihar, and it was held that BCCI is not a state or authority. See, BCCI has deep pervasive control. It also enjoys monopoly, but it is not performing any public duty. That is why BCCI is not a state. Now, is judiciary a state? So Article 12 does not explicitly mention judiciary, but sometimes judiciary performs legislative functions, and legislative functions are part of state as per Article 12. In that case, judiciary is state only when it performs legislative functions and not when it performs judicial functions. Article 13 talks about laws that are inconsistent with fundamental rights. A law can be pre-constitutional or post-constitutional. If a pre-constitutional law violates fundamental rights or a provision of fundamental right, then that law will be held unconstitutional, or that part which is inconsistent with fundamental right is held unconstitutional, as per Article 13 Clause 1. Now Clause 2 talks about laws that are made after Constitution. These are post-constitutional laws, and they cannot take away or abridge any fundamental right under Part 3. Article 13 gives power of judicial review to Supreme Court and High Court that can declare a law unconstitutional and invalid if it violates fundamental right. But what is law under Article 13? A law can be ordinance, rule, regulation, religious law, or custom. All these comes under definition of law. But there was dispute regarding constitutional amendment, whether an amendment is a law or not. That led to various cases on whether fundamental rights can be amended or not. So let us look at those cases one by one. In Shankari Prasad case of 1951, Supreme Court said that fundamental rights can be amended, But in Golaknath case of 1967, Supreme Court overruled its earlier decision and said that Parliament cannot amend fundamental rights. Parliament was furious regarding this and passed 24th Constitutional Amendment Act, which stated that the Parliament has power to amend the Constitution. Finally, in Keswanand Bharti case of 1973, it was decided that Parliament can amend the Constitution, but it cannot change the basic structure of the Indian Constitution. So for the first time, Supreme Court gave the basic structure doctrine. Now let us move to Article 14. Article 14. Article 14 says that the state shall not deny to any person equality before law and equal protection of laws within territory of India. So under Article 14, we will understand two concepts, that is equality before law and equal protection of laws within territory of India. Equality before law is concept borrowed from English common law. It is negative concept in the sense that it prohibits state. It means absence of any special provisions enjoyed by any individual in the eyes of law. In the eyes of law, everyone is equal. It means that a law treats everyone equally without any distinction, and it includes rule of law. Now let us understand what is the rule of law. This concept was given by A.V. Dicey. It means absence of arbitrary power, that is predominance of legal spirit, and no man can be punished unless and until he breaches law. गवर्नमेंट किसी को भी आर्बिट्ररीली पनिश नहीं कर सकता. So rule of law includes absence of arbitrary power, supremacy of law, and equality before law. Earlier it was rex lex, that is rule of king. Now it is lex rex, that is rule of law. Now let us understand equal protection of law. Equal protection of law is positive concept, unlike equality before law. Equal protection of law encourages state to take proactive steps in favor of weaker section. People of disadvantaged communities continue to suffer without intervention, and hence protective discrimination is essential. This is the essence of equal protection of the laws under Article 14. Now, there are some exceptions to Article 14. These are: President and Governor is not answerable to court of law for the exercise and performance of their duty under Article 361. Also, no criminal proceedings against President or Governor can be initiated, even there is no process for arrest for them. Also, foreign sovereigns and ambassadors enjoy certain privileges when they are in India. Also, whenever Article 31C comes in, Article 14 goes out. That means Article 31C, which says that while implementing certain directive principles, even fundamental right under Article 14 can be taken away. So whenever Article 31C comes in, Article 14 goes out. Now let us understand Article 15. Here there are 5 clauses. First 2 clauses speak language of equality before law, and clause 3, 4 and 5 speak language of equal protection of the laws. First clause says prohibition of discrimination only on grounds of religion, race, caste, sex and place of birth. Here the word only is important. If there is any other ground, then state can carry out discrimination. But only on these grounds, religion, race, caste, sex and place of birth, there cannot be any discrimination. Second clause provides for same but in public places. That is, no citizen can be denied access to certain places only on grounds of religion, race, caste, sex and place of birth. Now clause 3, 4 and 5 talks about language of equal protection of the laws. They enable state to do certain things. Clause 3 talks about special provisions for women and children. In other words, no one can stop government from making special provisions for women and children. Clause 4 allows to states to do same for socially and educationally backward classes of citizens and scheduled caste and scheduled tribes. Clause 5 is related to educational institutions, including private institutions, and it is regarding reservation. So clause 1 and 2 impose restrictions on state, whereas clause 3, 4 and 5 provide enabling clause for state to do something for betterment of those sections who are in need. Now let us move to Article 16. Article 16 Clause 1 says that there shall be equality of opportunity in public employment. Article 16 Clause 2 says that no citizen can be discriminated or made ineligible for employment of any office under the state only on grounds of religion, race, caste, sex, descent, place of birth or residence. So clause 1 and 2 again speak language of equality before law, that is they prohibit state from doing something, that is they are negative in sense. Now let us move to Article 16 Clause 3. It confers power on the Parliament to provide by law making residence as the criteria for employment, that is residence based reservation. Example, Mulk Law of Hyderabad. Now this is the homework to you. What is the Mulk Law? Explain it in comment section below regarding Article 16 Clause 3. So Article 16 Clause 3 is enabling provision. Similarly, Article 16 Clause 4 empowers state to make special provisions for backward classes in case of public employment. So this paved the way for class-based reservation. So Clause 3, 4 and rest subclauses are exceptions and they provide equal protection of laws. They are positively worded and enable state to make special provisions for backward classes. But what are the backward classes? Article 16 Clause 4 does not define backward classes. Even Constitution does not define them. In general, these are socially and educationally backward classes of citizens. And backwardness is not static. It should be revived periodically because ये change होती रहती है dynamically with respect to time. So let us understand reservation in public employment and otherwise and various commissions and Supreme Court judgment regarding this with help of timeline. Make sure that you are noting this down. In 5 minutes reservation के crisp and precise notes आपको मिल जाएंगे. In 1979, Mandal Commission was set up. It submitted its report in 1990. It identified 52% population as OBC and recommended 27% reservation for OBCs, additional to earlier quota of SC and ST reservation. Then in famous Indra Sahani case of 1992, also known as Mandal case, Supreme Court held that. Now note this down, it is very important. Total reservation shall not exceed 50%. Number 2, no reservation in promotion, that is reservation only at entry level. Number 3, creamy layer system where advanced section among OBCs would be excluded from the list of backward classes of citizen. So Ram Nandan committee was appointed. Why? To identify the creamy layer among the OBCs. See, in Mandal case, Supreme Court said that total reservation should not exceed 50% mark. But Tamil Nadu government wanted 69% reservation. So 76th constitutional amendment was added into constitution. It amended Schedule 9, the iron box, and listed Tamil Nadu Reservation Act of 1994 in that 9th schedule. See, if a law is added in 9th schedule, to save it, that law is free from judicial review. That is, the Supreme Court cannot review it. So 76th Constitutional Amendment Act added Tamil Nadu Reservation Act of 1994 in the 9th schedule. Also, Indra Sahani case provided for no reservation in promotion, but later it was found out that SCs, scheduled caste and scheduled tribe people are not adequately represented in top post in services. So 77th Constitutional Amendment Act of 1995 was passed, which provided for reservation in promotion in favor of SC and ST. As years passed by, it was found out that social justice was not achieved as many seats were unfilled. So 81st Constitutional Amendment Act was passed, which enabled carry forward policy, which meant that the unfilled seat of scheduled caste or scheduled tribes quota of a particular year to be carried forward to the next year. Finally, The recent 103rd Constitutional Amendment Act of 2019 amended Article 15 and 16 and provided for 10% reservation in government jobs and educational institutions for the economically weaker section, that is EWS, in the unreserved category. See, in India, we have vertical reservation and horizontal reservation. Vertical reservation is reservation for scheduled caste, scheduled tribes, and other backward classes, whereas horizontal reservation cuts through vertical categories, that is reservation for women, armed forces personnel, freedom fighters, reservation for disabled, that is horizontal reservation. So with all that being said, let us move to Article 17. Article 17 provides right against untouchability. But what is untouchability? Crudely, untouchability is social practice and it is mostly prevalent in the Hindu community, where discrimination against individual is solely on the basis of his birth. So Article 17 abolishes untouchability. It prohibits practice of untouchability in any form and even declares it's a punishable offense. Since Article 17 is not enforceable in itself, Parliament has to make laws for enforcement of untouchability. So for that, Parliament passed Untouchability Offences Act of 1955, which declared untouchability as non-cognizable and bailable offence. See, non-cognizable offences are of non-serious nature and punishment is usually less than 3 years. Also, these are bailable offence and police can grant bail. Example for such non-cognizable and bailable offences are misbehavior, cheating, etc. But cognizable offences are of serious nature and punishment is usually of more than 3 years. Offences under this, that is cognizable and non-bailable offences, include murder, kidnapping, dacoity, rioting, etc. But Untouchability Offences Act of 1955 had declared untouchability as non-serious, non-cognizable and bailable offence. So to make it more stringent, the name of the act was changed to Civil Rights Protection Act and the law made untouchability cognizable, that is serious offense, and non-bailable offense. Still it had some loopholes, such as it did not cover garlanding with chappal, it did not cover sexual exploitation. So there was need of a change, there was need of a new law. So in 1989, Parliament passed the Prevention of Atrocities Act of 1989, which included social and educational boycott, sexual exploitation, garlanding with chappals in untouchability definition and prohibited it. Under Prevention of Atrocities Act, a person can be arrested even if an FIR is filed against him without any preliminary inquiry and no anticipatory bail can be granted here. So I guess this much is enough for Article 17. Now let us discuss Article 18. Article 18 abolishes titles. It prohibits state from conferring any title except military or of academic distinction. Even citizens cannot accept foreign titles. Even a foreigner holding office of profit under Indian government cannot receive any title without consent of president and they cannot even accept gifts. See, here you should remember that awards are not titles. Award is for merit and they do not create artificial social distinction. They even do not use prefixes. Example, Paramvir Chakra, Vishishta Seva Medal, whereas titles they are often used as prefix and create artificial social distinctions like Raja, Rani, Rai Bahadur, etc. Now with all that being said, let us move to Article 19. Article 19 of the Indian Constitution guarantees 6 freedoms to all citizens of India, which are freedom of speech and expression, assembly, association, movement, residence, and profession. However, this right is subject to reasonable restrictions, which may be imposed in the interest of sovereignty and integrity of India, security of the state, friendly relations with foreign states, public order, decency or morality, contempt of court, defamation, or incitement to an offense. Now here you can refer this table for specific right and reasonable restriction thereof. Some points to be remembered are Article 19, Clause 1, Subclause A grants freedom to express views, opinions freely and openly via word of mouth, writing, painting, signs, symbols, banners, and tweets. Right to assembly under Article 19, Clause 1, Subclause B is available for peaceful purpose without arms. That is, right to assemble for peaceful purpose without holding arms. And it does not include right to strike. Right to strike is not a fundamental right. Also, Bandh is illegal as it is total shutdown, violates Article 21, that is right to life, and Article 19, that is six freedoms of others itself. And right to freedom under Article 19 is granted only against state and not against private individual. Simply you cannot move freely inside anyone's home. And as I said earlier, you can check this table for these rights and respective grounds of restrictions. Now let us move to Article 20. Article 20 provides for protection in respect of conviction of offences. It provides for no ex post facto, no double jeopardy, and no self-incrimination. See, this article states that no person shall be convicted of any offence that was not punishable at the time of committing it. But this is applicable in criminal laws and not in case of civil laws. Civil laws can be enforced retrospectively, but criminal laws can never be enforced retrospectively. It should be noted that any offence that was not punishable at the time of committing it, then person shall not be convicted. It also prohibits double jeopardy, meaning that no person shall be punished more than once for the same offense, but this applies only in judicial proceedings. There was a movie in Hollywood where a woman had killed her husband and court had sent her to prison. But actually, man had faked his death and she had been wrongly imprisoned. But as per plot twist, she was now free to kill her husband because no man or a woman can be sentenced twice for same offense. There are many ifs and buts, but I hope you get the point. So no double jeopardy means that no person shall be punished more than once for the same offense. Here the woman had already been sentenced for crimes that she had not done, so she was free to commit that crime because she has been already convicted for that. Additionally, the article provides protection against self-incrimination, stating that no person shall be compelled to be witness against himself. There is an exception: narco test, lie detectors are not admissible as evidence in court. But in civil cases, self-incrimination is admissible. Now let us move to the Article 21. Article 21 of the Indian Constitution guarantees every person, citizen or foreigner two fundamental rights, that is right to life and right to personal liberty. The Supreme Court has described this right as the heart of the fundamental rights. It ensures that no person can be deprived of their life or liberty except according to a procedure established by law. This right is available against the state only and not against private individuals. The goal of Article 21 is to ensure that any deprivation of life or liberty by the state is only done according to the prescribed procedure of law. Judicial interpretation has ensured the scope of Article 21 is not narrow and restricted, so Supreme Court passed various judgments. Let us look at them one by one. First, in A.K. Gopalan case, Supreme Court gave narrow interpretation to right to life. Supreme Court held that procedure established by law embodied British concept of personal liberty and not American due process of law. Now let us discuss the difference between procedure established by law and due process of law. Under procedure established by law, only executive actions are challenged in court and it is taken from British concept of personal liberty. Whereas in due process of law, even the legal sense of law-making authority is also challenged along with executive action. Hence, it provides extra layer of protection for individuals, their personal liberty, and gives larger meaning to right to life under Article 21. In upcoming landmark cases such as Maneka Gandhi versus Union of India, Francis Kurlai Mulin versus Union Territory of Delhi, and Unni Krishnan versus State of Andhra Pradesh, the Supreme Court has expanded the interpretation of Article 21. Right to privacy, right to shelter, right to education, and protection of cultural heritage. Now, Supreme Court, through various judgments, have gave a list of rights that Article 21 covers based on earlier judgments. Some of them are right to privacy, right to go abroad, right to shelter, right against solitary confinement, right to social justice and economic empowerment, right against handcuffing, right against custodial death, right against delayed execution, doctor's assistance, right against public hanging, protection of cultural heritage, right to pollution free water and air, right of every child to a full development, right to health and medical aid, right to education, and protection of under trials. Now, with all that being said, let us move to Article 21A. Article 21A guarantees the right to education to all children between the age of 6 to 14 and mandates that education should be free and compulsory as per Right to Education Act 2009. So, this is it about Article 21A. Now, let us move to Article 22. Article 22 ensures the right to protest against arrest and detention and stipulates that the reason for arrest must be informed. The detainee has the right to consult and be defended by a lawyer, and the individual must be produced before a magistrate within 24 hours. Now remember this: punitive detention is intended to punish an individual for the crime that they have already committed, while preventive detention is intended to prevent a potential crime from happening. Preventive detention is typically carried out without trial and based on the pre-assumption that the individual may commit a future crime. See, not many democratic countries have this provision of preventive detention. It is very unfortunate that India is having preventive detention law, but it is necessary for security and integrity of nation. But for prelims perspective, we don't need to go this much deep. Now let us move to the next article, that is Article 23. See, Article 23 simply prohibits trafficking in human beings and forced labor. Article 24 prohibits the employment of children under the age of 14 years in hazardous industries only, and the Constitution allows for children to work in non-hazardous industry. Therefore, the Child Labor Prohibition and Regulation Act to prohibit all kinds of employment below the age of 14 was required, and so it was enacted. So now all kinds of employment below the age of 14, even in hotels and dhabas, is prohibited, and in case of hazardous industries, this limit is to 18 years old. Now let us move to Article 25. Article 25 of the Indian Constitution guarantees freedom of conscience and the right to profess, practice, and propagate one's religion subject to certain restrictions such as public order, morality, and health. The state can regulate economic, political, and financial activities associated with religion. Now let us move to Article 26. Article 26 allows religious denominations to establish, maintain, manage, and acquire property for religious and charitable purpose. A religious denomination is characterized by a system of belief, common organization, and distinctive name as per the Supreme Court. Now next is Article 27. Article 27 prohibits the taxation of religious institutions and prohibits the use of public money collected as a tax for the promotion of any particular religion. कोई भी पर्टिकुलर रिलीजन के लिए उसको प्रमोट करने के लिए टैक्स में कलेक्ट किया हुआ पैसा यूज़ नहीं कर सकते. However, fees can be collected for providing services and safety measures. Now let us move to Article 28. Article 28 of the Indian Constitution prohibits the imparting of religious instruction in any educational institution wholly maintained by state funds. No religious instructions shall be provided in any educational institution receiving aid from the state funds. However, this provision does not apply to educational institutions administered by the state based on religion, language, or any minority community, or institution established under any endowment or trust. Now check out this table for more clarification. Make note of it and revise this. Now let us move to Article 29. Article 29 of the Indian Constitution provides for the protection of the interest of minorities, ensuring their collective right to conserve their distinct language, script, or culture. It prohibits any citizen from being denied admission to any educational institution receiving aid from the state on the ground of religion, race, caste, or language, whether from the minority or majority group. whereas Article 30 grants minorities the right to establish and administer educational institutions of their choice with freedom to choose teaching staff and enjoy the right to property. That means minority institutions को अपना teaching staff सिलेक्ट करने की चॉइस होती है. दिस implies only to minority institutions based on religion or languages and does not extend to any other section of the society. Now let us discuss Article 31. Article 31 of the Indian Constitution deals with the right to property. It states that no person shall be deprived of their property except by the authority of law, and that compensation shall be paid to the owner in case of acquisition of property by the state for public purposes. But this article was amended several times and finally it was repealed in 1978 in the 44th Constitutional Amendment Act. Now let us move to Article 32. Dr. B.R. Ambedkar has described Article 32 as the soul and heart of the Constitution. The provision empowers citizens to approach the Supreme Court of India for the enforcement of their fundamental rights. It states that an individual has the right to move to the Supreme Court by appropriate proceedings for the enforcement of their fundamental rights, such as the right to life and personal liberty, freedom of speech and expression, freedom of religion, and right to equality. That can be any fundamental right. The Supreme Court has the power to issue writs such as habeas corpus, mandamus, prohibition, quo warranto, and certiorari for the enforcement of these fundamental rights. Now, before discussing writs, let us discuss the concept of locus standi. Locus standi means the right to bring an action before the court. It requires a person to show their legal capacity before approaching the court. The principle only allows person to approach the court when their personal interest is affected or an injury is inflicted upon them. Now let us discuss the writs issued by the Supreme Court in order to enforce the fundamental rights, that is the writ of habeas corpus, mandamus, prohibition, quo warranto, and certiorari one by one. Habeas corpus literally means to have body. It is available against both public and private institution. When the individual is detained without legal justification, this writ is issued by court to set him free. Here, not necessarily the complaint has to be filed by aggrieved person. He is detained and then how can he appear before court? Hence, principle of locus standi does not apply here. Next is writ of mandamus. Mandamus literally means to command. This writ is issued in the nature of command by judiciary against a public authority or a person holding public office. The purpose of mandamus is to direct or command a public authority or official to do or not to do certain acts in the nature of public duty. Mandamus can be issued to implement a public or a legal right, not private right. So remember this. Next writ is prohibition. Prohibition means to prohibit. It is a writ issued by Supreme Court or High Court against judicial or quasi-judicial bodies, that these bodies shall remain within their power, and if such a body takes in excess or goes beyond its power, prohibition will be issued. It prohibits body from moving ahead in the case, and it is issued against judicial and quasi-judicial bodies. The next writ is certiorari. Certiorari literally means to be certified or to be informed, similar to prohibition, except that it is used or issued to nullify or quash already issued judgment by judicial or quasi-judicial body, which was beyond its jurisdiction. Since 1991, certiorari can be issued against administrative authorities also. Now last writ is writ of quo warranto. In the literal sense, it means by what authority or what warrant. The purpose of this writ is that person holding public office is qualified to hold that public office or not. Hence, it prevents illegal use of public office by person. So note down this table for future reference and quick revision. In addition to being a powerful tool for the protection of fundamental rights, Article 32 is also a reflection of the constitutional balance of power between the judiciary and the executive. By providing citizens with the right to approach the Supreme Court, the Constitution seeks to ensure that the judiciary remains a check on the executive, preventing any overreach by the government. Now let us move to Article 33. Article 33 of the Indian Constitution allows Parliament to restrict the fundamental rights of armed forces, paramilitary, police force, or intelligence if it is necessary to maintain discipline. This is done through laws made by parliament and not state legislature. State legislatures do not have this power. For example, the Army Act 1950, the Navy Act, these laws were enacted through the power given to parliament by this article 33. Now let us discuss article 34. Article 34 allows restrictions on the fundamental rights during martial law, which is not defined in the constitution. Martial law is not defined in constitution. The civil administration is run by military authorities during martial law. However, the Supreme Court has held that habeas corpus is not automatically suspended. Martial law affects only the executive and suspends ordinary law courts, whereas emergency suspends law-making authorities also. It is imposed, that is, martial law is imposed to restore law and order and is confined to specific areas of the country without any specific constitutional provisions. Now let us discuss the final article, that is Article 35 of the fundamental rights, that is Parliament's power to make laws for certain fundamental rights. See, Parliament has exclusive power to ensure uniformity in laws affecting certain fundamental rights. Only Parliament has these laws because it is necessary to maintain uniformity of these laws throughout India. Parliament can make laws to prescribe residence as criteria for public employment and to empower courts other than Supreme Court or High Court to issue writs. These are specific examples. C. Only Parliament can make laws to take away fundamental rights of armed forces personals under Article 33 and prescribes punishment for certain offences, for example under Article 17. Untouchability is not enforced in itself, it has to be enforced through the law, and that law has to be made by Parliament, and this power to make such laws is given to Parliament by Article 35. Now let us discuss some exceptions to fundamental rights under Article 31A, 31B and 31C. Article 31A, it is related to land reforms, industry and commerce, including acquisition of estates, management takeover and amalgamation of corporations, and these provisions are exempt from judicial review under Article 31A. And it is to be noted that when government takes over such property or such estate or such management, compensation is to be paid at market value. This is provided under Article 31A. Now let us discuss the second provision under Article 31B. Acts and regulation placed in the schedule, 9th schedule, are exempt from judicial review. But IR Coelho case of 2009 said that a blanket ban on fundamental right is not allowed. And even if a law is placed in Schedule 9 of the Indian Constitution, it is subjected to judicial review so as to ensure that it does not alter the basic structure of Indian Constitution. Also, it is to be noted that in 1951, there were only 13 laws in Iron Box, that is Schedule 9, but till 2018, 282 laws were placed in this Iron Box, that is Schedule 9. Now let us move to the next provision, that is Article 31C. Article 31C says that in order to implement socialistic directive principles under Article 39B and C, Article 14 and 19 can be compromised. That is, to implement socialistic directive principles, that is to implement directive principles, fundamental rights under Article 14 and 19 can be compromised. And 25th Constitutional Amendment Act 1971 prescribed no judicial review of such instances. But in 1973, there came a case, Keshwanand Bharti case. It said that you can amend fundamental rights and you can do whatever you can, but you cannot change the basic structure. You cannot alter the basic structure of the Indian Constitution. So with all that being said, let us move to criticisms of fundamental rights. See, there are limitations and restrictions imposed on fundamental rights, and these limitations are excessive and sometimes unreasonable. देखो Article 19 also is enjoyed with reasonable restrictions. So एक criticism है कि fundamental rights is not a bag of rights, but it is a bag of restrictions. Second, there is absence of social and economic rights such as right to work, right to employment and right to social security. So such type of rights are not mentioned in fundamental rights. Fundamental rights, political rights political democracy establish करने में काफ़ी helpful रहे हैं, but in case of establishing social and economic democracy, third criticism is there is lack of clarity. and some provisions and their interpretation by lawyers. देखो, Constitution of India is made by lawyers. The language of constitution is also complex because of presence of legal luminaries. It is said that the constitution of India is paradise of lawyers. देखो, there is ambiguity with reference to many keywords such as minorities, then states, then laws. So these are the loopholes because their interpretation is sometimes ambiguous. Number 4, there is no permanency with respect to the protection of property rights. देखो, फंडामेंटल राइट टू प्रॉपर्टी वॉज चेंज्ड कॉन्टिन्यूसली टिल 1978 एंड 1978 में तो उसको पूरा का पूरा अबॉलिश किया था विद द हेल्प ऑफ 44th कॉन्स्टिट्यूशनल अमेंडमेंट एक्ट. देर इज ऑल्सो सस्पेंशन ऑफ फंडामेंटल राइट्स ड्यूरिंग टाइम्स ऑफ इमरजेंसी. जब भी उसकी ज़्यादा ज़रूरत होती है तब सारे फंडामेंटल राइट्स सस्पेंड हुए जाते हैं. ओनली आर्टिकल 20 एंड 21 रिमेन्स. एंड फाइनली द प्रैक्टिस ऑफ प्रिवेंटिव डिटेंशन. जैसे कि मैंने कहा, the practice of preventive detention is not common in democratic countries. Now, with all that being said, let us move to rights outside part 3 of the constitution and ये chapter खत्म हो जाएगा. Number 1, no tax can be levied or collected without the authority of law, and this is given by article 265 and 266. This is not a fundamental right, but this is a right outside part 3 of the constitution. Then there is property rights and it is protected under article 300A. पहले आर्टिकल 31 में से उसे हटाया गया. इवन आर्टिकल 19 में भी था राइट टू प्रॉपर्टी, बट इट वॉज रिपील्ड एंड इट वॉज मूव्ड एंड मेड अ कॉन्स्टिट्यूशनल राइट अंडर आर्टिकल 300A. फाइनली, फ्री ट्रेड, कॉमर्स एंड इंटरकोर्स थ्रू आउट इंडिया इज ensured अंडर आर्टिकल 301 of part 13th of the constitution. Violation of these rights cannot be challenged in Supreme Court as they are not classified as fundamental rights. देखो, ये fundamental rights है नहीं है. These are only constitutional rights and these are outside part 3, and if they are violated you cannot go directly to Supreme Court or High Court. So this is it from this video. I hope you like this video. If you have any doubt regarding fundamental rights, you can comment below in the comment section. I will try to resolve your query there and there only. I hope these videos are helping you, and I hope this whole playlist is helping you in your revision. The whole purpose of this video is to make your revision faster and quicker. So this was the 7th video on revision series on Indian polity. You can find the playlist link down below in the comment section or in description box. You can also download these notes in digital format from PDF membership platform, or you can write down from the video itself. So thanks for watching. Have a good day.